most complex and challenging issues in the workplace is the issue of classification, or rather misclassification of a worker, employee versus independent contractor. Recently, Bill 148 addressed this issue when it amended the Employment Standards Act. The onus now falls on the employer when a dispute arises around classification, and the employer has to prove that there was in fact no misclassification. The province is also hiring on 175 new employment standards officers to enforce these regulations. They're also aiming to inspect 1 out of every 10 businesses in Ontario. So it's important that companies are mindful of the risks, legal costs, and consequences associated with misclassification. In 2016, the multi-million-dollar utilities retailer Just Energy came under fire for allegedly misclassifying thousands of its sales agents. The company alleged that these agents were contractors, independent contractors. However, they provided them with company-branded uniforms, sales scripts, training, discipline, performance management, basically treating them like employees. And just a few months ago, an individual filed a Ministry of Labor complaint against Domino's on the basis of misclassification, seeking 4 years of back pay on that basis. In a recent case against Lazy Boy Canada, the court awarded an individual 20 months of pay in lieu of notice on the basis that the individual was actually an employee and not an independent contractor, as the company alleged. So these risks are really important to be mindful of. The first set of risks fall under the Employment Standards Act, the ESA. That relates back to minimum wage, overtime, vacation pay. The second relates back to Canada Revenue Agency, CRA, taxes. And the third relates to wrongful dismissal. Like in the Lazy Boy case, if a court agrees that an individual is an employee, then they could be owed wrongful dismissal damages upon terminating their employment. The test that companies should be mindful of when trying to determine whether an individual is an employee or an independent contractor relates back to, number 1, control. Who has the control in the relationship? Is the company dictating the individual's schedule, the location of work, etc.? Number 2 relates back to tools and equipment. Who's providing the tools and equipment? The computer, the phone, the car, if they need a car to work. Is it the individual or is it the company? The third relates to financial risk. Is there financial risk for the individual? And the fourth, is there an opportunity for profit for the individual? And written agreements are always relevant. If there's a written agreement in place, it will definitely be relevant, but it won't be the determining factor. So if there's a misclassification, the written agreement alone cannot save you as a company. It's really important to get advice about these situations because these issues are often very tricky. So we always recommend to companies, when you're considering whether or not an individual is an employee or an independent contractor and how to classify them, it's important to reach out and get some advice. Ask a professional to ensure that you are protected from these risks.